Right. You ready? Okay, so we're going to be on the unit for contracts, real estate contracts. So the real estate market is driven by contracts. You have listing agreements, you have buyer representation contracts, sales contracts, options. Licensees must be knowledgeable on how a contract is created, what it means, what's required of the parties, what kind of actions can end the contract. So a big thing when you start with your broker is you're going to have to learn how to do a listing agreement. You're going to have to know what that listing agreement means and how to fill it out and how to explain it. You're going to have to know how to do a buyer agency agreement between you and the buyer. You're going to have to know how to fill it out, how to explain it. A sales agreement, you're going to have to know. And the addendums that we use commonly to attach to it. So that's a big thing when you first start, when you get licensed, is familiarizing yourself with these contracts. And typically what we'll do is we'll have you do a mock agreement, just make up a buyer and a seller, use your own house, and go through and try to fill in the blanks. And then we'll look at that. But the best way to learn, Sarah, is by doing it. And by doing it. Most offices have a manager or somebody that'll help you until you become good at it. And the contracts are always changing. So being familiar with contracts is a big part of it. Then you have contract law, which is tied in. So a contract is a voluntary agreement or promise between legally competent parties, supported by legal consideration, usually money. In some cases, it could be love and affection, that we were going to convey that property to Lex, not for any money, but for love and affection. Jake, we need to get Jacob to sign in. And for a legal act. We need to get him to sign it. The guy beside Jacob.
Oh.
Has to be for a legal act. Jason.
Yeah.
Right?
Yeah.
Sorry. So I need those name tags.
My name tag today.
You didn't get it? You didn't bring your name tag?
I didn't put my name tag today.
You didn't bring it.
No.
We're just gonna have to work with you. I usually have some blank ones. So a contract is a voluntary agreement or promise, and it has to be for a legal act. Real estate licensees may not practice law. So you're not allowed to practice law. You're not an attorney, okay? Typically, they are pre-printed forms, Jace, and you just fill in the blanks. Consumers may choose their own attorney. So we always give the consumer, if it's a listing, if it's a buyer agency, if it's a sales agreement, the right to choose to have an attorney review the paperwork when we do it. So there's different types of contracts. There's express or implied. These contracts may be oral or they may be in writing. But the contract may be implied by the acts and conduct. Boy, contract may be applied by the acts or conduct. I don't know, Lex and Vonnie are talking. Vaughn says, hey, I got a house for rent. Lex says, I'll rent it. Next thing you know, Lex is moved in the house. That could be that's an implied act, right? She moved in. So that could be construed as an implied contract. There's bilateral and unilateral. A bilateral contract, all parties promise to do something for another. So, Jacob, a sales agreement would be a bilateral. The seller agrees to sell for a monetary amount. Jason, a listing agreement would be unilateral. Only one person has to abide by the agreement. As a listing broker, I'm not required by contract to sell his house, but if I do, he's required by contract to pay me a fee. So know the difference between bilateral, typically a sales agreement, where one person's giving something to somebody else, or a unilateral is just one. Executed and executory contracts. An executed contract are those that have been fully performed. Executory contracts still require some performance. So an example of an executed contract would be Seneca and Samantha sell a property to Vonnie and Lex. Vonnie and Lex go through the process, get the mortgage, do the inspections, get the title search, close on the sale. When they close on that sale, that's an executed contract. An executory, you need to know the definition at least between these two, still requires some performance by one or more party. So an executory contract would be Vonnie and Lex have a contract with Samantha and Seneca to close on the sale, but it's contingent upon a home inspection, it's contingent upon them getting a mortgage, it's contingent upon them getting a title search. That would be an executory contract. Okay, it's still one or more parties still have something to do to complete it. So know those two definitions.
Wait, let's say that up for a second. I can't write this fast. Stop for a second.
That's on page 151 in your book. Page 151, scroll. You want to make a note of that.
Wait, go back 1 second. Wait. I'm still on bilateral contracts.
Okay. Well, what's the difference between a bilateral and a unilateral? What's a bilateral? Give me an example of a bilateral.
One.
No, bi means two, right?
Yeah,
bisexual,
unilateral.
bilateral.
Yeah.
Okay.
Yeah. So,
Bi means two. So that means both parties have to do something. Unilateral
it's one.
is one. One party has to do
So
something.
what's a one?
Listing agreement.
Okay.
The agent's not by contract required to sell the house, but if he does sell it, the seller has to do something, and that would be pay a fee.
So a bilateral would mean like a tenant agreement.
A listing, a lease would be a bilateral. An option would be a unilateral, right? An option agreement, because an option gives you the option to buy. You don't have to buy, but you have the option. But if you exercise your option, doesn't the seller have to sell? Unilateral.
So a listing agreement.
We all square on those two. May have a test later. Validity of contracts. They have to be, valid means all the essential legal elements are met. Void lacks some or all the essential legal elements. We'll get into those here in a second. Voidable appears to be valid, but may be rescinded by one or both parties based on some legal principle. If I have a gun and I put it up to Bonnie's head and say, buy this house,
No.
sign this contract, and she signs it, is that contract void? No. No. Even though I held a gun to her head, she still may want to buy the house. But it's voidable because if she doesn't want to, she can get out of it. Okay. So, right. Unenforceable appears to be valid, but neither party can sue the other for performance. Seneca, when I gave you that, no, you go ahead. Okay. Do you think we could work on this and maybe that sound? Is there anything else we can do other than make my speaker up? So we got to figure out how we're going to make this
Shield
work.
free online disclosure process is trusted by hundreds of thousands of agents and sellers.
I watched it yesterday. It sounded good. It sounded good.
Yeah, but we're having computer problems today.
Today, we are going to talk about what makes a contract valid, void, or voidable.
See how that's muffled?
Let's start with a valid contract. A valid contract is one that meets the basic elements of contract law. For
Good
example,
enough?
you signed to
Good enough
buy a
for
blue
you.
house, the house is blue, the contract is valid. Easy peasy. Next, let's discuss a voidable contract. So let's take that blue house. You signed to get a blue house, and you're very excited about your blue house.
There's
When
nothing
you
we can
show
do
up,
with it.
lo and
I'm gonna get a new
behold,
speaker.
the house is a hideous color green.
And I tried
Oh,
to
no.
get that in.
Now what do? Well, you have the option to rescind out of the contract because you agreed for a blue house. The house is now green. But this is not void. This is voidable because you may like that color green and maybe your thing. So you have the option to follow
We need to
through with
figure
that
that out.
contract.
I would
Contracts
figure
that
the
have
sound
fraud
needs to
or
come from
misrepresentation are also voidable. Also, contracts that are signed under duress. For example, if somebody's holding a gun to your head saying, sign this contract to buy this house, sign this contract, that contract is not void, it is voidable. Now you may be thinking, how's that not void? There's a gun to your head. Well, the fact is, even though there's a gun to your head, you may still want that house. So just because there's a gun to your head, should that take away your opportunity to buy the house? No. What the gun being held to your head does is it gives you the right to rescind. That is why that contract is voidable and not void. A contract that is void lacks one of the four essentials of a contract, which are mutual consent, lawful object, consideration, and capable parties. On your exam, they may ask you, what is the status of the contract if one of the parties is deemed mentally incompetent? Well, the answer there would be void, because it would violate the essential element of capable parties. Till next time, good luck on your exam.
So if the party is incompetent, then it would be void. If it would be void. So let's talk about the essentials of a valid contract. Mutual assent or meetings of the mind. The offer is made by one party. He would be the offeror. And the request for something in exchange for that promise may be terminated by rejection or a counteroffer. So somebody makes an offer on a piece of property. So Chase, you offer Jacob $100,000 for his property. Jason could accept it. You would be the offeror, right? He is the offeree. Okay, he could accept it. What happens if he counteroffers? It says, no, I don't want 100, I want 120. Now, Jacob would be the offeror because basically he's making a counteroffer to you. It's just like making an offer to somebody. Does that make sense? Okay. A lot of times in the offer, we have that they have to accept. So Jason makes the offer to Jacob. He may put a clause in the agreement saying that this offer is good for 24 hours. If Jacob doesn't sign it, then the agreement becomes null and void. So usually there's some type of time frame put in. Now, if Jace makes the offer to Jacob and Jacob counters, Jacob may put in the counter. This counter is good for a specific period of time. Does that make sense, Ray? Okay. Acceptance, the promise by the offeree to be bound by the exact terms posed by the offeror. So a lot of times, Sheila, somebody will make an offer to one of our sellers, and the seller will say, yeah, but they want me to include the garden tractor. I don't want to include the garden tractor. So let's counteroffer. Anytime they make any changes to that offer, it becomes a counteroffer. And we say to, or maybe they're asking, they want 100,000 and the guy offers 99 and he wants to counteroffer. We say, as soon as you change that agreement, any of those terms, that agreement's now void and you got to and you're making a counteroffer. Does that make sense, Lex? Mm-hmm. Okay. Counteroffer is basically a new offer. Consideration, something of legal value needs to be in it. Courts do not inquire into the adequacy of consideration. So if there's a dispute, the courts aren't going to get involved and say, you didn't pay enough. But love and affection can be considered consideration. You have to have legally competent parties. How old do they have to be? Okay. They have to be a sufficient mental capacity. Right, Sarah? It has to be for a legal purpose. If Azaria wanted to buy a piece of property off of Lisa, and the reason she wanted to buy that was for some type of illegal enterprise, that could be a voided agreement because it has to be of legal purpose. The statute of frauds. Oral contracts may be valid, but in certain situations, a contract must be in writing. And when it comes to real estate, they must be in writing to be enforceable. The statute of frauds requires that all contracts for sale of real estate be in writing and signed by the seller to be enforceable. We have this situation sometimes. And we're going to talk about the next meeting on Monday at my office. So let's say that Jason makes an offer to Vaughnie. Jason's an agent, Vaughnie's an agent. Okay, so Jason has a buyer, they make an offer. And Jace doesn't send the offer over in writing, but he calls Vaughn and he says, hey, Vaughn, I got an offer on your house for 100 grand. Bonnie says, let me talk to the seller. Talks to the seller. Seller says, yeah, they'll accept it. Bonnie calls Jason back, says, yeah, they'll accept the offer, Jace. Is that a legal contract? It's not in writing. But you know what? Agents do it every day. You know the danger of that? When it comes to money, people get funny. So even though Bonnie agreed verbally to accept your offer, Jace, before you got it written up and got your buyer to sign it, Lex went to Vaughn and says, hey, Vaughn, I got a buyer to pay 110. Here's the contract. Vaughn says, shit, I didn't sign anything from Jason. Here you go. She signs it. Jason calls Vaughn up and says, hey, I got the offer written up. I'm going to send it over. Vaughn said, too late. They signed another offer. Jason says, what do you mean? I told my buyers that the property was yours. That they got the property because you verbally told me. So even though it's not legal, now that agent is in trouble. Because guess what? The buyer's going to sue. And guess who he's going to sue first? You. And we have that problem a lot with a lot of verbal offers, verbal counter offers in the business. And every once in a while, 9 times out of 10, they go verbally back and forth, come to terms, put it in writing, and there's not a problem. But every once in a while, a fly in the ointment like Lex comes in and screws it up, and the seller says, shit, I didn't sign anything. I want an extra 10 grand in my pocket. So now, Jason, your buyer wants to sue you for misrepresentation, wants to sue the seller because the seller verbally told him that the offer was his, and it just turns into a big mess. It just turns into a big mess. So don't be one of those agents that take those shortcuts. Okay? The statute of frauds require all contracts be in writing to be enforceable. See the Real Estate Commission's rules or regs about the use of written contracts. We're going to be getting into that in, I think, chapter 12. Parole evidence rule states that a written contract takes precedence over an oral agreement. So, in this case with Jason and Vonnie, at the end of the day, when it gets down to it and goes to court, the court's probably going to favor Vonnie and say, Vaughn, you had a written agreement with Lexi that overrules the verbal, but in the meantime, you got time and money tied up in it. She's got time and money tied up in it. The agent's got time and money tied up into it. And a lot of times these attorneys will settle versus going to court, and then your E&O kicks in. I told you, I just paid a claim for $13,000. The seller told the agent verbally after we had a deal, I get roots in my sewer lines, they get plugged up. The buyer said, no problem, I'm a plumber. We didn't take that next step and put it in writing, and we went to mediation, and it cost us $13,000. 13 grand. It's a big mistake. It's a big mistake. Okay. Now, luckily we have E&O, so we only had to pay the deductible of that 13. But still, what happens when you have an insurance policy and you always have claims against it? It goes up. So how do you discharge a contract? Okay. How do you discharge a contract? Performance of the contract is the most desirable outcome. What do we call that? An executed contract at that point or an executory? What? Executed. That means the contract has been fulfilled. Executory, Jacob, because you're giving me poopy face, means that there's still some conditions, either that or crypto just dived. You're not getting alerts. Okay. Executory would mean that there's still something that has to be done. So performance of a contract is the most desirable outcome. Time is of the essence. Most contracts stipulate when the contract has to be fully performed. Okay, so when we have a sales agreement and I'm off and Jason wrote that offer up to Vonnie. Well, he didn't write the offer up. That's right. He did a verbal offer. Lexi wrote the offer up. Lexi put it in that agreement when the settlement date would be. And time is of the essence. So she puts in her settlement date's going to be in 30 days. February, what's today's date? 25th? 27th? Oh, I'm 2 days behind she puts in there February 27th. On February 27th, you better close that transaction or somebody's in default. If Lexi's buyer doesn't have the money, she could be in default. Unless she had some kind of contingency. If it was contingent upon getting the money, it'd be a different story. Okay? So time is of the essence. Failure to perform is breach of contract. If no time frame is stipulated, contract should be performed within a reasonable time. Sometimes I get these wild agents from these other companies don't put a settlement date in. When we pick up on that, we send it back, say, no way, Jose. But some of them don't. They say, and an example, Ellen, of somebody not wanting to use a settlement date would be if their buyer has a house to sell. They'll say, we'll make an offer, we'll give Bonnie $100,000 for that house, contingent upon selling our house. And when our house sells, we'll move forward. They don't put a settlement date. You still have to put a settlement date in. Maybe 90 days, but you still have to put some type of a date in. In practice, contracts usually provide for a number of events that must occur by certain dates. These are performance dates, okay, and are legally sufficient. So an example would be, because Lexi has a contract with Lonnie, right? What happened to Jason? He's in litigation. But in Lexi's contract, she may have a certain amount of events that have to happen by specific dates. So she may make the offer to Vonnie. She may put in there that the offer has to be accepted within 24 hours. That's a specific date. If Vonnie signs it within 24 hours, and Lexi has a contract, she may have another clause in there that states that she has to give her buyer has to give her the hand money within 3 days. She may have another stipulation or contingency that her buyer has 10 days to do a radon test, or may have 10 days to do a home inspection, or 10 days to do a well inspection, or has to start mortgage financing within 5 days, has to get the mortgage approved within 3 weeks. So there's all kinds of dates that you have to, when you put a deal together, you're a real estate agent, you need to know these dates because your buyer and sellers are going to forget about them, and you need to prompt everybody and kick everybody along. Hey man, you got 3 days to get that septic inspection. You better get on the stick, or if you go past that, then you may lose the right to do that. Okay. Assignment is transfer of rights and obligations under a contract to a third party. So I had an offer on Bill's golf land. It's up for sale. Okay. 3.8 million, I think it's listed for. And in the agreement, my buyer wanted me to put a clause that he could assign his agreement to another entity. He says, if they accept my offer, I may want to create an LLC. And isn't an LLC different from an individual? He said, I may want to create an LLC. So I want to be able to assign that to the LLC. Sometimes they don't want people to know who the buyer is. So let's say you have, because if the buyer is a big corporation with a lot of money, they think the price should go up. So sometimes an attorney will be the person making the offer, and he'll put in there that this offer is assignable, and then they'll assign the offer if it's accepted, because if he knew that Amazon was buying it. You think if somebody knew Amazon was buying their 10 acres versus Vaughnie, they'd want more money from Amazon? Yes. Notification is a substitute of a new contract in place of an existing. And it may be between the same parties or a new party. Notification, know what it is. Substitute of one contract for another. Breach of contract. The contract can be terminated if it's breached or broken. So if Lexi put in that agreement that she would close in 30 days to Vaughnie, and 30 days come and she doesn't close, Vaughnie can terminate that agreement. Maybe she'll extend it, give her a little bit more time, or she could terminate. If Lexi doesn't get the hand money from her buyer within that 3 days, Vaughnie could terminate the agreement, or maybe she'll extend it. Okay? Breach is a violation of any terms without legal excuse. There you can't give it, there's no excuses. Unless an agreement of sale specifies otherwise, if the seller defaults, the buyer may enter into suit for specific performance. So, at the end, Vaughnie, she sees dollar signs and she gets crazy. She really does. So, Lexi made her an offer for $100K. She already cut Jacob out, but not Jacob, but Jason, right? So Lexi offered 110. We're in contract now. Buyer's getting inspections. Samantha came over to Vaughn and says, "Hey, I got somebody that'll give you 120. Well, Vaughnie's client seeing dollar signs. So now she tells Lexi, "I ain't closing." Well, if the seller defaults, and Lexi's buyer's ready to close, but Vaughnie's seller doesn't want to sell because she wants to get more money from Samantha. So buyer can sue Vaughnie for specific performance and make her sell that property. Because they already have a contract. Okay? If the buyer defaults, the seller may sue for damages for the purchase price and tender of the deed. Okay? So let's say Lexi's buyer, all the contingencies are met. Now remember, her buyer offered Vaughnie 110, right, Ellen? And Lexi's buyer just says, "Well, my boyfriend kicked me to the curb and I don't want to buy the house." Fuck, that happens a lot. A lot of kicking to the curb going on, especially with COVID. Okay? So Vaughnie could then sue Lexi, buyer. Could sue her for the purchase price. Because now Samantha's buyer went away at 120, and the only buyers left is who? Jason. Jason's looking his chops back there. Vaughnie sues Lexi, buyer, and says, "I'm suing you because you offered me 110. Now the most I can get for the house is 100. I'm suing you for the difference. I'm suing you for utility bills because I'm going to have to keep the house on the market for an extra 2 months. I'm suing you because I had an offer on another house and now I'm going to lose that." So when the seller defaults, the buyer can sue for performance to make it conform to the agreement. When the buyer defaults, usually the seller is suing for damages, liquidated damages. Now, this is an easy chapter, ain't it? The computer's working, God willing, right? Thank God we got 3 laptops here, huh?
One of them has to be.
Jesus Christ. Yeah, but the sound doesn't work right on it. I don't know how we're going to figure that out.
I'm still working on these slides.
But this is easier to explain because it's a little bit more common sense stuff. Does that make sense? Not all that legalese. They were like special warranty, general warranty, deed in trust, trustee's deed. Who gets a deed in trust? Who signs a deed in trust? Who? Trustor. And who's he signing it to? The trustee. I can't remember the other one. Who was it? Trustee? Who was it? No, trustee and deed is the trustor to the trustee. What kind of deed when the deed goes out of the trust? What?
Deed in trust?
Deed in, what is it? Trust,
Trustee's deed goes.
trustee's deed. Trustee, trustor's deed. What is it?
Trustees is out of trust.
Trustee's deed is out of trust? Okay. Hey, I don't know. I deal with a trust maybe once every 5 years, 10 years. And usually I let the attorneys handle it. I'd have a problem passing this test. I'd have a problem with it. Glad I don't have to take it. Oh, Jesus Christ. I just said, thank God the computer's working. Son of a bitch. Huh?
And that's a different one.
Those laptops that are not.
What's that?
Those laptops you got there,
Oh, there it goes. These are newer laptops.
Yeah, but they're not ready. Have a bunch of memory and stuff on them.
The statutes of limitation is the time limit in which enforces rights. Recession, how do you pronounce that? Is that recession? R-E-S-C-I-S-S-I-O-N?
No.
It's not. It's recession. Anybody know recession? In real estate, is the right of rescission is the right to rescind, cancel a contract involving the sale of property or a mortgage for a refinance. In the sale, both the seller and the buyer may have the right of rescission if certain contingencies are not met. So somewhere in that contract, and our contract's about 12 pages, there's some language in there that says if Lexi's buyer can't get a mortgage, she has the right of rescission to get out of the deal. Not cost her any money. There's a clause in there that says if Lexi's buyer does a home inspection, does a radon inspection, does whatever, she has a right of rescission to get out of the agreement if that contingency is not met. Contracts may also be discharged or terminated by the following. Partial performance. The parties agree that it's close enough. The parties agree that it's close enough. So let's say that Azaria has a contract with a builder to build a new house. Okay? Has a contract. And in that contract, it says that the house has to be in broom clean condition, all the windows have to be cleaned. And we get to the end of the contract, and the builder says, I'm done. And Azaria says, but you didn't clean the windows. She may be able to, the builder may be able to argue, well, it's close enough. And they may be okay. Builder may be okay. That's just an example. Partial performance. Substantial performance may be sufficient to force payment. So I guess a judge would make a call if those windows are substantial performance or partial performance. Was it close enough, or does the builder need to go in and clean the windows? If there's 5 windows and they're all on the first floor and anybody can clean them, the judge may say, that's partial performance, that was close enough. If it's a 10,000 square foot house, 3 stories high, and to clean the outside of the windows is going to cost a ton of money, may be a different story. impossibility of performance, legally impossible to perform the required act. Mutual agreement. Everybody just agrees and signs off on it. Or, bless you, an operation of law. As in voiding of a contract because of a minor fraud or improper alterations of a contract. What the heck we mean by that, Lise? Improper alterations of a contract. Does it say anything in the book about that? I'm curious to know myself. What do you think, Jake? What do you think that means? Improper alteration of a contract. Jacob.
So, like a situation where the tree was going into plumbing and they were set up. That page is gone, written up, and not receive the signature from the buyer.
Yeah.
Or they made an amendment.
Oh, that's, you're on the right track. Yeah, let's say Bonnie and Lex had a binding contract signed by all parties, and then after the fact, Bonnie made a change to it. And Lexi didn't agree. That could be an option. I'm not 100% sure. Let's see if we can get this video to work. And you're saying that other computer just will not boot up and will not do anything, huh?
I couldn't get it. It opened that first time, but then.
Why don't you put a call into Case and tell him if we leave this at the leave that computer at the office, can he clean it up for me?
Yeah.
See, I'm going to click on this video and it won't let me click on it because when I go over it, look what I'm getting.
Okay.
I don't think his computer has the right software.
I don't see a video there.
It's right here. Look,
Where? Oh, I see.
right there. So when I go to put my mouse over it, nothing.
Well, yeah, because that pops up.
Because what?
That little box pops up.
Well, how do I get that box to go away? Now, man,
It's just.
I spoke too soon, Tam, didn't I? Again.
Scroll
I got-
over from the right, like go in a different.
Nope. Nope. Nope.
You
Nope.
scroll up in the side, probably not.
Contract videos. Let me see if I can find something. See, Prep Agent has a 48-minute video on. I was thinking of doing it today. I was going to play an hour video. Good thing I didn't, because if the speakers were good, I'd get away with that. I'd go out there and make phone calls or something. Here, let's see what Prep Agent has here on this one. Prep Agent has here on this one. Well, shit, that's me on there. Oh, shit, that's me.
That was filming live.
Wait, that was freaky, wasn't it? I'm telling you what, I'm getting killed here with this computer. We're gonna have to skip the video.
Yeah, it's still live. Oh, okay. Oh, man. That's pretty fun.
Contracts used in the real estate business. So we talked about listing agreements. Everybody knows what that is, right, Sarah? Everybody knows does everybody know what a buyer agency agreement is? Does anybody, if you know what a buyer agency agreement is, put your hand up. Okay. So a buyer agent, so does everybody know if you know what a listing agreement is, put your hand up. Okay. Ray, do you know what a listing agreement is?
No, sir.
Okay. You were my star boy here too. I thought you'd be the guy to pass this thing for no matter what.
Yeah, it's just, this one's totally different.
There's a lot, huh?
Yeah.
And you know what? I have a feeling some of you have a life outside of this classroom. So when you leave here, you got other stuff you have to do, right?
Yeah.
So it's hard. Like it's not, it's hard. Like if you can go home and you didn't have anything to do, and you didn't have a house clean, kids take care of, all that other stuff, maybe go to another job, it would be easier because you can study all week. But life takes over, and we got other stuff to do, don't we? Okay, so listing agreement. A listing agreement, think about the word, listing agreement. So a listing agreement is where a real estate broker has a contract with a seller to list his house for sale. So who's the listing agreement with? Who? And who? And the seller. Okay. A buyer, buyer agency agreement. Who do you think his contract's with? The buyer and the broker. It's where the broker has a contract with the seller. So if you're a buyer, Elise, and you call me up and you say, hey, Tom, find me a house. I'm going to say, hey, Elise, will you work exclusively with me? She'll say yes. I'll say, okay, I'm going to prepare a buyer agency agreement between you and me. And it's going to spell out that if you find a house, regardless who finds it, I'm paid a fee. Listing agreements, there's several different types of listing agreements, but typically with a buyer agency agreement, if the buyer finds a house, the agent gets a fee. So every once in a while, I have one of my agents come to me and say, hey, I had a buyer agency agreement with a buyer, and guess what he did? He went and bought off somebody else. And we can take that buyer to the magistrate and hold his feet to the fire, and he can owe us a fee. So a buyer agency agreement is between the buyer and the broker. A sales contract. Everybody, put your hand up if you know who the parties would be of a sales contract. No. Buyer and seller. Okay. Option agreement. An option agreement may be between a buyer and a seller, where the buyer has an option to buy the property if something happens. So maybe the buyer says, if I sell my house, I'd like the option to buy your place. And the seller says yes and signs the contract on that option. Is that option agreement a unilateral or bilateral agreement? No, because the buyer has the option to buy. So it would be unilateral. When the buyer has the option to buy share, he don't have to buy. But if he decides he wants to buy, does the seller have to sell? Yes. Okay. Escrow agreements. They're used. Sometimes the seller, Lexi had a home inspection on Bonnie's house. The home inspection said needed to put a new electric service in. We got to closing, and when Lexi's buyers did a final walkthrough, they said to Lex, they never put an electrical service in. So we may go to that, but she says, but I'm screwed, man. Mom's kicking me out of the house. I got to be in something tomorrow. So we may go to Bonnie and say, hey, we're still going to close on the sale, but we want to do an escrow agreement. It costs about $2,000 to put electrical service in. How about if we escrow $3,000? We'll close on the sale. Bonnie takes $3,000 out of our proceeds, puts it in an escrow account. and then once the electrical service is done, wanting to get that money back. That's a good example of an escrow agreement. It happens a lot. Maybe it's real cold and they don't get the paint, it's an FHA loan, and they don't get the paint scraped and painted. Why would the FHA require paint to be scraped and painted anyway? Because they spent. Okay? So that's an example. What's that?
Who's holding that money?
Usually an attorney.
The buyer.
It could be whoever they agree upon. It could be whoever they agree upon.
Do you ever hold it?
No, I don't hold it. I don't even know if I can legally hold it. Typically, an attorney holds it. Typically, it's the attorney that's handling the closing. Whatever, and that's typically your right to buyer's attorney. But it could be the seller's attorney. Both parties agree on it. You'd have to have an escrow agreement spelling that out. That's what the escrow agreement, that's a good question, because that's what the escrow agreement could spell out. Who's holding the money? Who's holding the money? Leases, we all know what a lease is, right? Lease agreement. Who's the lease agreement between? Lessor and lessee. Which one's the landlord? Lessor. Did we make copies of the OREE rule? Okay. And then land contracts. A land contract, you would think, Jace, it's for land, wouldn't you?
Yeah, I would see
I mean, so there may be a question on a test. Who could be a part of a land contract? Or the land contract is for 10 acres of land. That's not what a land contract is. A land contract is an agreement between a buyer and a seller, and the seller holds the financing and keeps the property in his name until it's paid off. And then when it's paid off, the property is conveyed to the buyer. So my second real estate property that I ever bought was a duplex in Jacobs Creek. And I bought it off of Bob and Betty Smith. It was a duplex in Jacobs Creek. And I told, Bob says, hey, Tom, why don't you buy that? He knew I was in real estate because I sold his house, another property for him across the street. And he said, why don't you buy my duplex? And I said, Bob, I would, but I ain't got no money. Didn't have no money. He says, I'll do owner financing. We'll do an installment land contract. Keep the property in my name. Have an agreement prepared. You'll make payments. Once it's paid off, I'll sign a deed over to you. That's a land contract. Okay. And then I kept it for 10 years and paid it off. And then when I paid it off, he had a deed prepared conveying the property into my name. Even though really for that 10 years I owned it, I collected the rent, I paid the taxes, had to pay insurance and show him proof. But it was a land contract. That's what a land contract is.
It's kind of like a rent to own.
No, because a rent to own is an option. Or the rent to own is renting, and then so much of your rent is put towards the payment if you move forward and buy it. And typically it's a unilateral contract because if the tenant doesn't move forward and want to buy, he doesn't have to. Okay, a land contract would be a bilateral contract because both parties are bound to act. If I make the payments, I get the house, he's obligated to sign it over.
Does that go through a broker or does that just go through an attorney to draw paperwork for that? Is it the same as?
You know what, I had an attorney prepare, have a settlement, did a title search to make sure he didn't own any crazy mortgages on it. And typically an attorney prepares that. Usually brokers don't prepare that kind of documentation. They could, by law, agents can't, brokers could, but typically we get an attorney involved, let an attorney do it. Licensees may not provide legal advice. The consequence is a criminal offense. Jace, you can go to jail. Jared, you could pay $2,500 fine, and you go to jail for 1 year. Okay. The real estate commission can come after you for disciplinary action. We were here Tuesday. The real estate commission was in my office Tuesday doing a inspection. Okay. So they could take your license off of you. Licensees are permitted to fill in the blanks in the direction of the client. And you may not charge a fee for doing that paperwork. Now, you could charge a fee. If I had that buyer agency agreement with lease, I got a buyer agency agreement. Lease is going to make sure that I get paid a fee. Because in that buyer agency agreement, usually it spells that I'm going to make X amount of dollars. And if I don't make that on a transaction, if the seller's not paying it or whoever, then Lisa will pay that. But I can't say, I'm going to charge you to prepare a sales agreement. The Plain Language Consumer Contract Act promotes the use of plain language to protect the consumers. Documents are typically exempt. So when you get a mortgage, good luck trying to read it. The Pennsylvania Electronic Transaction Act. In Pennsylvania, the consumer now can sign digitally. Could sign a sales agreement, could sign a listing agreement. I don't think we're quite there with deeds yet. So in most cases, the title company wants to send the deed to the seller to sign, and he would sign it and then overnight it back, get in front of a notary. But notarized acknowledgements are permitted electronically. So you may be able to do a deed. I just haven't seen it in my practice, but it's very, very typical that we do the sales agreement or a buyer agency agreement or a listing agreement electronically, even if the guy ain't far away. I may show Sarah a house, and she may live in Ross Draver and I live in Ross Draver. And she may say, she calls me up and says she wants to make an offer. I may say, how about if I prepare the contract, send it over to you digitally, you can sign it. Easier, quicker. You don't have to spend a couple hours with somebody. Now, at my office, I have a special form that's a disclosure. Because how many times do you think people come and say, I signed it digitally, but I didn't know what I was signing, and you didn't explain it to me. So, but I have a special form saying that I send you the documents with the form's first page. And it says, we recommend that you read these forms over. If you have any questions, that you contact an attorney, because I'm going to be sending you these forms digitally. And once you sign them, you're going to be bound to them. You know, because people are suit crazy. So, you know, you got to do what you can do to protect you. And people are always saying, I didn't know what I signed. So now I send people the agreement first, whatever agreement, with that disclosure. And then I'll send them the forms for them to digitally sign. And make them sign the disclosure that I sent them before that. So they can't come back on us. Okay, I'll tell you what, we're killing it today. Too much, too fast? We got through 8, 9, and 10 today. Are we still recording? We can end that. We got through 8, 9, and 10. So now we're going to take a 15-minute break. And I'm going to decide